Hi everyone. Thank you for joining today's webinar. The topic for today's webinar is gearing up for the draft amendments to the e-commerce rules in India. The webinar will be moderated by Mr. Indranil Choudhury, the CEO of Lexplosion, along with Abhishek, Namrata and Darir, all Lexplosion lawyers. We will also be joined by our guest panelist for today, Ms. Priyanka Gulati, Head of Legal and Compliance at the Tata Business Hub.
Good afternoon, everyone, and welcome to Lexplosion's continuing series of webinars. Thanks for sparing the time to join us for this session on gearing up for compliance obligations proposed under the draft amendments to the e-commerce rules. I am Indranil, and I, along with my colleagues Namrata, Abhishek, and Darir, who are all lawyers in Lexplosion, will be discussing some of the key changes proposed by the draft amendment to the e-commerce rules, which were placed before the public for its comments in June this year. Later in this webinar, we'll be joined by Priyanka Gulati from Tata Business Hub, who will help us in understanding how the industry is gearing up for the anticipated changes to the compliance obligations under the proposed amendments to the e-commerce rules through a Q&A session. Before moving further, we wanted to inform all attendees that this session was recorded slightly ahead of actual time of presentation to ensure that there are no last-minute technical glitches. However, we'll all be available to take questions at the end. As most of you attending today's webinar are aware, the e-commerce industry was brought under a set of specific guidelines for the first time last year when the e-commerce rules were notified under the Consumer Protection Act. These rules have come under further regulatory scrutiny in the draft amendments, which are the subject of our discussion today. The government has received comments from the public and is now in the process of finalizing the draft amendments. There are reports that the draft might be diluted to a certain extent as a result of the feedback from the industry and also inputs from Niti Aayog. We will do another session once the final amendments are notified. Before getting into a discussion on the draft amendments, here's a quick refresher on the original rules. The e-commerce rules prescribed an enhanced level of disclosure-related compliances, both for inventory-based as well as marketplace e-commerce entities, some of which are around mandatory disclosure requirements such as display of business-related information on the platform, geographical locations of its headquarters and branches, and details of its website. Further, marketplace e-commerce entities have the obligation to provide the main parameters used in determining the ranking of goods or sellers on its platform and the relative importance of those parameters through an easily and publicly available description drafted in plain and intelligible language.
Thanks, Indranil. I'd further like to add that there are some other compliance requirements around setting up proper mechanisms to ensure a time-bound consumer grievance redressal, which would also include appointment of a grievance redressal officer, besides setting up processes to allow consumers to keep track of the status of their complaints. Secondly, there are compliances around appointment of nodal officer or an alternate senior functionary who necessarily needs to be a resident in India to ensure compliance with the provision of the Consumer Protection Act and these rules. And then also there's this requirement that there's no discrimination between consumers of the same class, which may affect the rights as consumers. And then an e-commerce entity would also need to obtain express consent from the customer and record it while selling goods or services to them. And marketplace e-commerce entities have an additional obligation to ensure that there's a system in place to assist consumers by providing them with details of relevant sellers, including principal geographic address of the headquarters, branches, along with necessary information for communicating with the seller for effective dispute resolution in the instance of dispute with sellers. And there remains scope for further clarity to the extent of what could be considered as necessary information for effective dispute resolution. And if this requirement is allowed to remain unfettered, the extent of obtaining information from sellers remain foggy, which might end up casting onerous liability on marketplace e-commerce entities, thereby deterring them from onboarding small or new sellers to their platform just in order to avoid liability.
So another aspect covered by the 2020 rules is pricing and cancellation. So e-commerce entities are aware of the market conditions and essential nature of the goods and services. It is very easy for them to impose an unjustified price on consumers just to gain profit. So the rules have mandated that e-commerce entities must ensure that they do not manipulate the price of goods and services that they offer on the platform. And the rules have also cast an obligation on e-commerce entities to only charge cancellation on consumers when a similar cancellation policy is imposed on the e-commerce entity. So, say when I cancel an order that I have placed through an e-commerce entity, based on the company's policy, I am bound to pay a cancellation charge. So, in a similar manner, when the e-commerce entity unilaterally cancels the order, they must also pay a cancellation charge to the customer.
Right. Now, on that note, another point which is closely related to cancellation is the fact that inventory e-commerce entities may not refuse to accept a return or refuse to refund consumers or even discontinue services purchased or agreed to be purchased if the goods or services are defective, deficient, spurious, or if the goods or services are delivered later than the delivery schedule, except, of course, if such delay is owing to a force majeure situation. This comes across as a tough compliance obligation for an inventory e-commerce platform.
Also, compliances have been prescribed with regard to due diligence, wherein, firstly, the marketplace entities need to adhere to due diligence requirements which are applicable to intermediaries prescribed under the Information Technology Act and the new intermediary guidelines. Secondly, maintaining records of sellers who have repeatedly offered goods or services that have been removed from the platform for violating intellectual property law.
Thanks, Dharir. Now, in the interest of everyone's time, may we now take this discussion forward to the core topic for the day, which is the draft amendment for the 2020 rules?
Sure, Abhishek. Beginning with the overarching applicability, registration requirements, and the grievance redressal related obligations. If the draft rules are notified in its current state, then all e-commerce entities will need to compulsorily register themselves with the Department for Promotion of Industry and Internal Trade, or also known as the DPIIT, and they have to ensure that the registration detail is displayed for users, which means that A, e-commerce entities and all their associated as well as related parties would now need to register themselves with the DPIIT, and B, foreign entities selling goods in India will also need to register with the DPIIT.
You make an interesting point there, Darir. As we know, the definition of e-commerce entities is anyway quite broad. And as we'll see later in this discussion, the definition has been broadened even further in the draft amendments. What we'll need to see is whether even a courier company which delivers e-commerce goods or a FMCG company which sells directly to customers through its portal will also now need to get registered with DPIIT. Maybe Namrata can help us answer that when she's speaking about the broader definition.
Sure, Indranil. Continuing with the discussion, the draft amendments prescribe requirements around providing ranking for goods in case of imported products, while also ensuring that the ranking parameters do not discriminate against domestic goods and sellers. This, coupled with the need for providing the country of origin for every product and the mandate to provide suggestions on alternatives to ensure fair opportunity to domestic products, seems to be an attempt to level the playing field between Indian and foreign sellers on e-commerce platforms.
Absolutely, Darir, and that does seem to be a bold step. However, the requirement to suggest Indian alternatives can end up being a double-edged sword, in my view. Providing suggestions for one Indian product over others can also be considered discrimination of some sort. So the algorithms to determine these suggestions need to be written very carefully.
That's an important point, Indranil, and there could be implications of making these suggestions on the position of e-commerce entities as intermediaries under the intermediary guidelines of the Information Technology Act. And moving on to the next key aspect of the draft amendment, there is a requirement to appoint a chief compliance officer, a resident grievance officer, a nodal contact person who needs to be present on a 24/7 basis on all e-commerce entities, irrespective of their scale of operation. The requirement to designate a chief compliance officer is over and above the obligation to appoint an Indian nodal contact person or an alternate senior designated functionary to ensure compliance with the provision of the Act. Now, the rationale for appointing multiple officers for a purpose which seems to be functionally overlapping is questionable, and these additional compliances most certainly will have a cost implication and might end up being prohibitively expensive for new entrants to the e-commerce sector, thereby decelerating the growth of smaller e-commerce businesses.
Absolutely true, Abhishek. As a matter of fact, 3 additional full-time employees, all of them residing in India, will throw practical challenges of various kinds of for all sorts of businesses, which can now qualify as e-commerce players because of the broadened definition.
Right, Indranil, like you were saying, been expanded or is proposed to be expanded to include those engaged by the e-commerce entities for fulfillment of the orders along with related parties. So this has several implications. So on one hand, delivery partners, payment portals, internet service providers, and a myriad other agencies which help e-commerce entities fulfill their orders will be considered as e-commerce entities. And to the point Indranil was making earlier, this might require them to get registered with the DPIIT. And on the other hand, related parties with a common chain of directors and common shareholders, or anyone else who might be a small cog in the giant e-commerce ecosystem may also come under the ambit of this all-inclusive new definition of e-commerce entity. So further, this would entail compliance burdens for small vendors and partners beyond just the DPIIT registration. They might have to, appoint all the compliance officers, grievance redressal officers, nodal officers, along with a horde of other compliances, merely because of their association with the e-commerce entity and, their role in fulfilling the order that is placed on the platform.
Absolutely, Namrata, if I might say that this is probably at the core of what makes these draft amendments so contentious. And I'm sure those reading business news are aware of the ripple effects that the proposed amendments, specifically these parts, have been causing. But it is probably best to delve into greater details of that only after the rules are finalized.
Thanks, Namrata and Indranil. That was rather insightful. Now, I'd like to take you through another key aspect of proposals in the draft amendments, which relate to advertising and selling. Logically speaking, adverts precede the offer for sale of a product. And therefore, let's start off this section with compliance requirements proposed around misleading advertisements. And then I'll move on to the aspects of selling. E-commerce entities will now need to ensure that misleading advertisements are not displayed on its platform or even otherwise, thereby extending the liability of e-commerce entities to have systems in place to keep a check that advertisements of all products sold on their platform or even advertised offline outside their platform is not misleading. I guess we need to see how this requirement eventually gets notified in the final rules.
And Abhishek, if I may, I think it will be interesting to check with our panelists as to what kind of duty of care this really places on marketplace e-commerce entities. I mean, for example, if I am putting up a product on a marketplace claiming that it is fit for use for a particular purpose, how exactly is the e-commerce company supposed to validate that, especially with potentially millions of such products being presented through their portal? And it does not stop with just misleading advertisement, but also casts a rather onerous responsibility on e-commerce entities with regard to mis-selling, right, Namrata?
So yes, Indranil. So both the Consumer Protection Act and the draft e-commerce rules deal with this concept of mis-selling. So mis-selling is, instances of selling goods or services by deliberately misrepresenting information or making positive assertions of false information of goods, services in an unwarranted manner only to convince a buyer to purchase the goods and services, and they're thinking that all this information is useful. So the rules have prescribed that sponsored listing of goods and services need to be distinctly identified with clear and prominent disclosures around the same. So this may also require e-commerce entities to maintain extensive and detailed records of all the goods and services that are sold by them at any time in the platform. So this will work as documentary evidence to back up any claims that are raised against the platform if they're accused of mis-selling. Further, there's also this additional requirement to ensure that the best before dates of any product are prominently displayed. So all of this will hopefully ensure that chances of mis-selling are reduced. But all of this comes at a cost, which has to be borne by the businesses as a result of all these requirements and increased implications. What is interesting to notice is the impact that this will have on the sector.
Thanks for the detailed explanation, Namrata. Now, I would like to quickly bring in the related concept of cross-selling. We might have noticed from time to time while purchasing products on e-commerce platforms, we get additional suggestions on products related to our purchase. For instance, upon buying a mobile phone, we might get suggestions to buy mobile phone covers or other accessories, which we might not have planned or intended to buy in the first place. Therefore, cross-selling is the system of sale of goods or services which are related, adjacent, or complementary to a purchase. The draft rules have proposed that in such instances of cross-selling, the e-commerce entity needs to provide adequate disclosures on its platform in a clear and accessible manner, detailing the name of the entity providing data for cross-selling and data of such entity used for cross-selling. There is scope for further clarity on this, and we would like to understand this further to better assess the compliance liability arising thereof.
And I completely understand that the regulator's philosophy behind these regulations of misleading advertising, mis-selling, cross-selling is to ensure that the end user has a better experience and does not end up either buying the wrong product or a product that they do not need. What probably needs to be balanced out is how it can be practically entrusted. This responsibility can be practically entrusted to e-commerce companies.
Agreed, Indranil. Now, we'd like to direct our attention to the concept of fallback liability. And this provision casts a liability on marketplace e-commerce entities if a registered seller on a platform fails to deliver goods or services to the consumer, thereby causing a loss to the consumer. While one understands the reasons behind these draft rules, this provision might end up casting an onerous liability on marketplace e-commerce entities for misdoings of sellers without them having the necessary oversight or virtually no control over the selling entity or the quality of products sold on the marketplace e-commerce platforms. For example, to what extent e-commerce entities providing platforms for people to trade on their used products can be held liable for errors by sellers on the platform is something which is worth considering for this instance. Further, there is scope for clarity on what qualifies as loss to the consumer and may lead to activating the provision of fallback liability. On the flip side, however, the e-commerce entities might get deterred from onboarding small sellers on their platform in order to avoid fallback liability. We'll be taking further views on this from Ms. Gulati shortly.
Before taking the discussion to Priyanka, we would like to take you through the contentiously discussed issue of ban on flash sales. So flash sales are proposed to be barred to the extent that such sales are organized by fraudulently intercepting the ordinary course of business using technological means with an intent to enable only a specified group of seller or sellers which are managed by an e-commerce platform. Last but not the least, the fulcrum of any e-commerce business model is the logistics service providers, whose role is to ensure that the consumer receives the product which he has ordered. The role of logistics begins as soon as we place an order on any platform and start tracking the status of the delivery, wherein The e-commerce platform also promises 2-day delivery, or it can even be a 30 minutes delivery. The draft amendments extend the compliance liability towards logistic service providers to ensure that differentiated treatment is not provided to sellers of the same category. Obligations are also cast upon logistic service providers engaged with a marketplace e-commerce entity to provide a disclaimer, including the terms and conditions governing the relationship with sellers on the marketplace e-commerce entity platform, along with a description of any differentiated treatment which it gives or might give between sellers of the same category. These obligations, coupled with the potential extension of the ambit of e-commerce entity to logistic providers, may end up increasing their compliance liability.
Absolutely, Darir, and thanks to you, to Namrata and Abhishek for, I think, wonderfully packaging this whole set of draft guidelines for our audience today. As we have discussed, these are still in the early stages of drafting, and we still don't know what the final rules will look like. But with these rules as the background, we would now like to introduce our guest for today, Ms. Priyanka Gulati. With several years of rich experience in management, corporate and secretarial laws, business laws and general legal affairs, Priyanka has a strong background in corporate compliance advisory. Priyanka has been associated with e-commerce giants like Walmart and Amazon and other e-commerce businesses for over a decade, and is presently engaged with Tata Business Hub as the head of legal and compliance. Please join us in welcoming Priyanka for her valuable inputs to today's discussion. So Priyanka, thank you so much for taking the time out from your busy schedule and joining us today. We really, really appreciate that. So Priyanka, as I already introduced you, you've obviously got a lot of experience in this space. So we wanted to, get into a conversation with you to really understand from your perspective how these draft rules pan out and whether they're making sense. Starting with, for example, this whole process of registration with DPIIT. How do you think that will impact e-commerce companies? What's your thought on that?
Thanks, Indranil. Thanks for having me with you. Thanks, the entire team. The rules has brought a storm in the e-commerce industry, as we all know, and everybody is contemplating and discussing the same. On your question on the registration, yes, the rules are pretty unclear on whether it's a straightforward process. You just go and get yourself registered, or there'll be any pre-scrutiny for the registration, any audit kind of thing. We would like to have more clarity on that in the rules. Also, apart from e-commerce industry, its related parties and associate parties are also supposed to have a registration, which we believe can be an added burden for a group as a whole. And by the provision of this, if there's any foreign company who doesn't have an office in India but still doing the selling, by way of e-commerce, also needs to be registered. That's how the rules currently says, but we expect more clarity on the way of registration and what's the prerequisite for the registration.
So the way you said it, and even I read it that way. Let's say Harrods has a portal online through which somebody from India can buy products, or any of these other famous retail outlets. Technically, so your reading also is that the DPIIT registration will have to be done by them as well?
Yes, that's what the current rules in their form says. Let's see if they come up with more clarity on that. I think we all are on the same page.
Right. So this is obviously going to be quite, so a lot of these foreign brands, which many of us have bought from over the years, probably, find it uncomfortable to do business with Indian clientele if this remains as a concept the way it is. So the next question I had for you, Priyanka, is on this whole thing of having 3 different officers on the permanent payroll of each e-commerce entity. I mean, again, of course, there's a larger question of even foreign entities and people who do not have an office in India, but even for Indian entities, to lot of companies don't do, e-commerce sale as their core business, but they do use that platform to do some amount of selling, including some of these software as a service companies and so on and so forth. So for each one of them to have a chief compliance officer, a grievance redressal officer, and a nodal officer, do you think it will end up being a barrier to entry for newer e-commerce players? Of course, also for the larger players, and I'm sure it will be a problem for them, but especially for the newer e-commerce players.
Yeah, it's definitely going to be a burdensome for some of the e-commerce players, especially the startups. As we all know, the bootstrap startups, they're mostly tight on funds, and they already have a bag full of worries on their related to their product, their hiring, and etc. The list goes on for the problem when it comes to problems for the startups. And then they don't need an army of people to deal with the problems, and neither I don't think there's a need also. And then over and above, you're asking them to have 3 full-time employees. One of them as a nodal officer needs to work 24/7 to liaise with the government. That's definitely seen to be one of the cost to the e-commerce players, and also of course the added compliances. I believe that cost can be added to solving their product problem, to creating product, to creating their capacity for the better customer experience from the business perspective. I mean, when Amazon started their business way back in 90s, they had only 11 employees.
Right.
If in the current scenario, if you'll talk about 11 employees, 3 of them goes for the compliances in the Consumer Protection Act. So yeah, it's going to be a worry for a startup, especially for the startups.
Yes, and also the fact that we already have the requirement for the grievance officer under the Information Technology Act itself, right?
Correct. Yes, and there is a limit where, based on number of users, registered users on the website. That still seems a bit notional, because the big companies, like big social media companies, they can really afford that, and so it makes sense for them to appoint it. I think the Information Technology Act has come up with a great problem to solve this. Under the current rule also, I think the department should look in the same way.
Right, absolutely. So no, so that's I think something that will hopefully get more clarity once the rules, the revised rules are brought back into public domain, because clearly, while maybe there is a specific purpose behind the framing of the rules, I don't know whether they've really thought through the fact that this e-commerce industry does not just consist of a few very large companies, but is actually a very large platform involving very small players, SaaS products, for example, which are sold online. The other portion, Priyanka, I guess the portion which is bothering most of us is this whole thing about the definition of the e-commerce entities being broadened to include the likes of logistics partners, related parties, associated entities which are used to fulfilling orders, which could potentially include technology service providers, payment partners. So as a lawyer who has been working in this industry for over a decade now, how do you think this will impact the overall business model of the e-commerce players? Do you think the people will have to relook at their entire value system and the value chain that they're working in, or do you think people will find their way around this?
So first of all, I think if you are anyway associated with an e-commerce entity, doesn't make you an e-commerce player, right? True. Like e-commerce, like logistic, as you mentioned, and other support services, they might not even have a online presence in itself. They are more of a support service providers for e-commerce. So only because they're related to e-commerce doesn't make them e-commerce entity, as per my practical experience. It's unclear about what the rules what the regulations they are trying to achieve to have them in the e-commerce definitions. I think that's they're curtailing the way of them getting into a business market and doing the more business. They're restricting the the business, the way they can do business, by adding all these registration compliances and other compliances which are there for e-commerce. Yeah.
And also the fact that they have talked about this whole value chain of companies which are used to fulfill or complete orders, so to speak. Now it's difficult. And my own reading of this is it can get quite complicated, because who all gets covered by that? Do all these payments, does a Paytm now become an e-commerce company and therefore need registration under
The
DPIIT?
definitions of related party and associate enterprise is very open-ended currently in the draft rules. We should have some clarity. I believe Niti Aayog has also put across the same point, which is supposed to be a think tank for the government. Let's hope we get some clarity on that piece.
Right.
Yeah.
So Priyanka, the next point that we wanted to discuss with you is on this whole thing of mis-selling and misleading advertisements. Now, even for a B2B platform or a pure e-commerce marketplace, this might mean having to verify in each and every statement of every person or business selling on their platform. How practical do you think this is, especially for a marketplace where there is very limited line of sight to what is being sold, and I can completely understand restrictions around any kind of criminal activity, etc. But how do you think this whole thing of mis-selling and misleading advertisements, how do you think they will pan out?
So I think I'll read the rule as the rule clearly says that there has to be a deliberate and positive act on behalf of the e-commerce entity, which leads to mis-selling or misleading the customers. So that means there's an additional burden for e-commerce company to make sure that they maintain the documentation or audit trails on the website, that there was no act on their part, and it's all third parties product. It definitely needs some technological advancement from the e-commerce player, and I'm sure everybody might have started thinking around that, on working around what technology they can establish or build to deal with this the problem.
Right. I'm sure there are new technological innovations that are already being thought about by especially the big players, which brings me, almost segues into the next question around, all these e-commerce platforms have a lot of, AI-driven algorithm to rank products or help clients prioritize their choices. Now, there's a fair amount of restrictions that these draft amendments try to place on this by saying that domestic products should not be ranked lower than international products, so on and so forth. Now, how do you think this is likely to impact the e-commerce business? I'm sure you have lots of operational colleagues from the industry. How are they worrying about this? Will they have to rewrite all their algorithms? Will I still get recommendations basis the last book I've bought or the last article that I bought, or will it all go away soon?
So I'll have tech people think about that, but I think this definitely is a most controversial in the draft rules. If you're selling an imported product, putting a country of origin, name of importer, these are the two compliances under the rules which you can still live with. It's added for compliance, but it'll not change your entire business structure. But the third one, where you have to give a domestic reference of any domestic goods when you're selling import goods, it's to me, I don't know how it's going to work. Am I going to have the entire team of people in the market where I'm selling import good to find a similar domestic offering to offer on my platform? So and we need to understand the rationale of a customer. If a customer is a luxury buyer, if somebody wants to buy a Mercedes S-Class, they are anyways not going to do the research on any Indian-made sedans. Their choice is pretty clear, right? And also, when somebody is doing a necessity buying on any of the e-commerce players platform, so they will only choose domestic products when they will find value in that. And if the domestic products can give value in that, I'm sure that customer is that smart that they'll find a way to find that product.
Right.
If somebody wants to buy Patanjali, they will buy Patanjali, even if you offer them any other imported brand. So it's as rational of a customer. They need to, the products itself needs to develop domestic products. They need to give value to the Indian customers.
Right.
So what about the subscription-based plans like Netflix? So if Netflix is showing a Hollywood movie, do they have to give the domestic movie for every Hollywood movie they're showing? suggestions. To me, it seems impractical. Or what about Google Play? Like, if any of the app is getting built in the Silicon Valley and it's listed on the Google Play in India, do they have to give reference of similar domestic apps? There are a lot of unanswered questions, and I don't know how they will find answer to it. It seems vague to me.
True. As a matter of fact, it might end up being more discriminatory because they might
Correct. Yes.
give two names of Indian brands, but not the others. And that will add to the confusion, so there might be questions about the basis for choosing those two ahead of the others and things like that. So who knows where this whole story will go.
Yeah. I think these rules have gone far beyond what Customer Protection Act needs to do. Their focus is to protect the interest of the customers, and are they so elastic that they go beyond and makes the rules which are already, I think, a lot of rules are already covered under FDI. Some are under data privacy, some are under competition law. Unfair trade practices, let's say, for example, are already covered under Competition Acts, and they have all the authorities to do that. So let's see how they comes up. Interesting times.
As a matter of fact, I was just reading recently that there was a Reuters article, as a matter of fact, about how even the finance ministry has come up with a list of 12 objections to these draft rules, and said that some of, at a time when we are talking about light touch regulations, to have a regulation like that, these draft rules is difficult to accept, and they have actually gone on to say that it will be a huge dampener and to revisit the basic business model. I mean, e-commerce companies will have to revisit the basic business model. So I think there is some expectation basis, whatever the Niti Aayog has said, what the finance ministry has said, that things will be probably a little different from what was originally presented in the June draft.
Yeah, there are a lot of criticism, and I'll not say criticism is not, a lot of objections and a lot of inputs have gone from the industry in these rules. And as you said, the government is also looking into that. And it needs to, focus, it needs to go along with your, the central government criteria of, the ease of doing business and all that. All your regulations should be around that.
True.
Yeah.
So no, thank you very much, Priyanka. I think this was a great insight. We are more theoreticians, and we look at law more from the from the theoretical aspect. But you've experienced this whole thing in the real world. So to get your perspective on this was really fantastic. I think there are a few questions from the audience, and we will now go to those questions. So please stay with us.
Sure, happy to. Yeah.
So there are a few questions that have come in. Priyanka, can you hear us?
Yes, Indranil, I can hear you.
Hi. I'll try and go through the questions, and whichever ones you want to take, let me know. Otherwise, we'll try and answer them. So the first question was from Parag Redkar, who says, for each e-commerce platform, do we have process or a portal in place to lodge a complaint such that tracking against number is possible? I think that's the first question. So
I think there's already a mechanism under the Information Technology Act where all the e-commerce players needs to have a grievance officer in place, and there's already entire guidelines on that. And under that, you get a separate tracking number for all your complaint raised that needs to be resolved in 15 days. And there's an entire set of guidelines that are already mentioned in the Information Technology Act.
Yes, and also there is a requirement now. Earlier it was a good to have, but now in the draft rules it is said that every portal has to be connected to the National Consumer Helpline of the central government. So I guess that will be another way of really resolving any of the problems that people face. So I don't know whether that Parag Redkar, I don't know whether your question has been fully answered, but essentially yes, there is a mechanism already in place under the Information Technology Act, and of course now under the draft rules there is a requirement for a grievance redressal officer separately. So between these two and the fact that there is a requirement now to link every company's portal with the National consumer helpline. Hopefully, there will be a mechanism in place to address all of these grievances. The next question is from Mr. Rahul Chatterjee. Do these e-commerce rules apply to an online marketplace for connecting buyers and freelancers for digital marketing services?
I believe till the time you are providing services and goods to the B2C customer, to the end customer, the Consumer Protection Act applies to you, and consequently the guidelines as well. You might be excluded if you are a B2B commerce or B2B platform and providing services to businesses. That's my current understanding.
Yeah, as a matter of fact, the way, if I can spend a minute to just go through the definitions that are here. An e-commerce entity means any person who owns, operates, or manages digital or electronic facility or platform for electronic commerce, including any entity engaged by such person for the purpose of fulfillment of orders placed by a user on its platform, and any related party as defined under Section 276 of the Companies Act, but does not include a seller offering his goods or services for sale on a marketplace or e-commerce entity. So the seller is not does not need to be registered, but the platform and all those involved in the fulfillment of these orders, as is mentioned, will have to be included. So, Mr. Chatterjee, at least my reading is till the draft rules are modified, which they are likely to be, yes, the e-commerce rules will apply to an online marketplace for connecting buyers and freelancers. Yes, so to that extent, it will apply. The next question is from Mr. Shaurya Sinha. Will the rules be applicable to B2B e-commerce? And I think the answer is yes. E-commerce, both B2B and marketplace e-commerce entities are covered by the e-commerce rules, which are already in place since 2020, and the draft rules have not made any specific exception for B2B e-commerce entities, at least for the moment. So probably the answer is yes. The next question, Priyanka, again for you. A few platforms have sellers who are individuals from different geographies. Then how does the Consumer Protection Act, how would the Consumer Protection Act categorize, define, penalize with respect to seller responsibilities versus portal admin responsibilities? And I think, Priyanka, you briefly covered that, so I don't know whether you can hear us. Okay. Priyanka did cover that to a certain extent during the Q&A. So I think, the principal responsibility will remain with the seller, but till the time the documentary proof can be given by the e-commerce platform that they took all the steps possible for them to take in ensuring that mis-selling and things like that haven't happened, they will also bear a portion of the responsibility. So I think that is the sum and substance of this, that there is a obligation on the e-commerce platform itself, both B2B and marketplace, to ensure that there is no mis-selling which is happening, but the fundamental obligation will remain the sellers. Okay, so Mr. Saurav Chatterjee has asked, what are the criteria to qualify for an e-commerce entity? I think I just quickly went through the definition. That should answer your question. We can come back to that if there is time towards the end. The next question is from Sunita Kangyola. Are these rules applicable for the entities which with own manufacturing and their own selling products online? So I guess that's a question. There are a lot of companies which have their own e-commerce platforms. So Priyanka, that question is definitely for you.
Yes, I think it definitely, if you're selling online, that makes you, again, if you're selling online to the customer, that you fall under Consumer Protection Act, and consequently the draft rules gets applicable to you.
Yes, so I think fundamentally, yes, that's the answer, that if you are a manufacturing company who has a website through which you sell your products, unless some subsequent clarifications are provided, as of now, it does seem like the rules will apply to you. The next question is from Mr. Arnob Sen. does the draft e-commerce rules dilute the safe harbor defense applicable for intermediaries under the Information Technology Act? Priyanka, do you want to take that?
Yeah, I do believe there's certain clauses like fallback liability that they have put on e-commerce. It definitely dilute the entire purpose of safe harbor and its related sections under IT Act. They both don't go in hand. Yeah, but let's see how this come up. That's my understanding. It definitely have some clashes.
Yes, and Arnab, to your point, there is definitely this whole situation of if you have to rank Indian products, if you have to go into understanding which Indian products can be ranked alongside foreign products, you will have to go beyond the standard role of an intermediary, and to that extent, definitely the safe harbor does seem to get diluted. We do have time, I believe, for 2 or 3 more questions. The ones which we are not being able to take now, our apologies. We will try and respond to you over email if your email ID is available to us. The next question is, ABC entity has a platform and its subsidiary XYZ is providing the fulfillment services. Which entity will be determined as an e-commerce? If I can answer that, I think both. As it is, as the new definition currently states, so by virtue of being the platform, ABC entity will be a e-commerce entity, and by being an organization which is helping in the fulfillment of the order, there will be the XYZ will also have to get registered as an e-commerce entity is my limited understanding. Just to clarify, there has been a lot written in the last few days, as a matter of fact, about how there is a lot of pushback on the draft e-commerce guidelines. So it's likely that we will see some changes. So how this whole thing actually pans out will probably depend on the feedback, and a lot of companies that we know of have given their comments or critique to the draft e-commerce rules. So it's likely that some of this will get changed. Mr. Arnab Sen asks, company A has 100% FDI and manufactures product X in India and sells his product via retail and e-com channel within the territories of India. Would they be regarded as inventory-based model? If yes, then FDI isn't permitted in inventory-based model. Wouldn't this e-commerce rules conflict with the FDI norms? Fundamentally, yes, Mr. Sen, it would be okay. If it's okay with you, can we take this offline? Because this is definitely a little more complex than what we can answer in a quick 30-second response. So we will take that offline, and we'll gladly get into a discussion with you on this. Does it impact on sellers also, and how? Priyanka, do you want to answer that? This is a question from Syed Najish Ali. Does this impact sellers, and if so, how?
Yes, so there are different set of compliances that are also being set for the sellers on the e-commerce platform. So it's already there, but the rules all clarify more and add more compliances for the seller as well. Say, example, they need to have a customer support and needs to be mentioned, and etc. The list goes on. Yeah. So yes, it definitely have some compliances on the seller as well, not just e-commerce.
Sure.
Eventually, they are the ultimate sellers of the product to the customer. E-commerce are just an aggregator to.
Sure. Next question from Kaushalya Madhavan. Will fintech entities facilitating payment options for e-commerce entities be considered as e-commerce entity under these rules? I think we discussed it during the Q&A session. As of now, it does seem like yes, but obviously we would hope that the rules kind of clarify on that. Mr. Parag Jain says whether there will be any additional compliances relating to e-pharma business. There are some e-pharma rules separately being drafted currently. Priyanka, if you want to answer that.
Please go ahead, Indranil.
Yeah, so on e-pharma, there are another set of guidelines which are being drafted for e-pharma, and there are some existing pharmaceutical rules which anyway apply to them. As far as e-commerce draft e-commerce guidelines are concerned, yes, to the extent that they fall within the definition of e-commerce, which they do as per the current definition, yes, the draft e-commerce guidelines will also apply to them. Will internet banking amount to e-commerce activity? Mr. Chatterjee, I don't think so. That does not seem to be the purview of the e-commerce. So I do not think any of the retail banks will become e-commerce entities merely by virtue of providing internet banking, and therefore, if they're not, then the rest does not follow as well. Mr. Arnav says, if an agent is purchasing the goods from a manufacturer locally and selling it through an online website, will he be included under the e-commerce guidelines? If an agent is purchasing the goods and selling it, yes, if they're facilitating the productions, Mr. Sen, I think your questions are fairly specific. Maybe we should take them offline. In my mind, again, if they're a regular agent who are selling goods on the e-commerce platform, then the obligations of the seller will apply to them, unless the platform belongs to them or unless they're a part of the process of fulfilling the orders. And I don't think when they talk about fulfilling the orders under the e-commerce draft e-commerce rules, I do not think they're talking about the sellers. I do not think they expect this because then every reseller on the platform or every restaurant, Swiggy, will become an e-commerce entity. That's probably not the not the intention of this enactment. I know that there are a few more questions, but we are absolutely running out of time. There is a question from Mr. Alok Pal, which says whether B2B operator needs to abide by it, customer sentiment. Sorry, I'm not entirely sure what the question is, Mr. Pal, but we'll happily take this offline. Will it be available to direct selling industry to the extent that they are selling through the e-commerce platform? The answer seems to be yes. CPA already has draft rules for direct selling industry. Yes, there is. I think the definition of related party should be relooked upon, as currently it covers many other entities like agents, logistics companies, etc. What is your thought? Priyanka, I think, has already mentioned that this definitely does look like something that needs further relook. With that, unless I've missed any of the questions which any of my colleagues would want me to point out, I think we are absolutely out of time for today's session. So whatever questions we could not take in this session, especially some of the questions which are very specific to certain modes of transaction in the e-commerce space, I think we will take them offline, and we will try and answer them over email if we have your email IDs. We will also share this presentation with all the people participating in today's session. We will also be sending a feedback form, which we would really appreciate if you can answer. With that, we'd like to thank Priyanka again for sparing the time. Really appreciate your time. Very incisive, insightful thought process on all these aspects. Like I said earlier, as theoreticians, we kind of tend to think of this in a very different way. So you gave really good insight. So thank you so much for your time.
Thank you, team. Thanks, Indranil.
Thank you. Thank you very much. With this, we are ending today's webinar session. We hope to see you again in the next one, which should be happening very soon in early part of October. Thank you very much. Thanks a lot.
Thank you, everyone. Thanks.
Thank you.